Welcome to the Law Simplified. I'm Bandaranayake. Today, we'll break down a question on parliamentary sovereignty. In the absence of a written constitution, the United Kingdom Parliament is the sovereign law-making power incapable of limiting its own power or being limited by an external power. Discuss. Now that we have outlined the question at hand, compared to many other subjects within an LLB, you would note that when it comes to constitutional law or public law in some syllabuses, the questions that are posed to you require some philosophical and analytical thinking. It is historic in nature on the one hand, but on the other hand, it requires you to have an opinion, have a point, and always be very direct in your approach. Most students tend to waver in this approach by considering the fact that there is a lot of content in your subject matter and an examiner expects you to write everything that you know. This is a fallacy. In terms of constitutional law, much like any other subject, you are expected to address the question. While there might not be many case summaries or case law associated with certain philosophical questions such as this, you are expected to showcase your opinion and your analytical abilities. Having said that, let's consider this question, and much like several other questions in contract law, in criminal, tort law, and others that we have discussed, let's have a mental highlighting process going on in terms of this question. Once we do so, we are able to identify what exactly this question requires us to do. Now, once we have this mental highlight done, you'd note that there are three major elements that they are considering. Firstly, there is a question related to the absence of a written constitution. Now, for the observant among you, the rationale behind considering this at the very outset of the question is so that you are able to create an approach into the actual question, being parliamentary sovereignty. UK is famous for not having one specific document, as in no particular written format of a constitution, much like many other countries do. The rationale for this is because there has been no break in the history of the United Kingdom following the 1066 Norman conquest. Now, the very aspect or the fact that UK's constitution is actually made up of case law, of statute, as well as certain academic sources as well, both legal and non-legal, means that this creates an opportunity for you to segue from the constitutional aspect to that of parliamentary sovereignty. The next aspect that has been stated in the question is that Parliament is the sovereign law-making body. Now, this is the first point in which the question indicates towards parliamentary sovereignty. And finally, it talks about the fact that parliamentary powers cannot be limited by itself as well as any other external power. Now, this question requires discussion in relation to the concept of parliamentary sovereignty as a whole, and what an examiner as well as the question expects you to do is to put it within context, namely by discussing the principles that have been outlined by A.V. Dicey. Now, considering that fact, what are the issues at hand that are expected for you to be discussing? On the one hand, it wants you to discuss what is meant by an absent constitution. Now, what we considered earlier was this absence of a break in the UK's history, and therefore there being no need for a particular constitution or written format. Rather, the constitution, if you are to consider it as such, is made up of several legal and non-legal sources. Once you have established this fact, the next element that it requires you to consider is what principle is being considered when it's stated that no one can limit the lawmaking rights of Parliament. Now, it's quite clear from the facts of the matter itself that it requires you to discuss parliamentary sovereignty. But more than that, if you agree with this statement or not. And in order to do so, the most important aspect is to consider A.V. Dicey's exposition, or the three limbs or the three pillars that he has expounded. Now that we have an overarching idea of how this question is to be approached, the most important aspect then to consider is to go back and look at a spider graph that you might have created for this particular topic. A spider graph provides you with an opportunity of having a bird's eye picture of all the elements in any given topic, in this case, parliamentary sovereignty. Now that we have identified that particular topic in hand, we need to eliminate at the outset anything which does not relate to the question at hand. Now, I must stress that examiners do not expect you to write every single thing you know about a topic. Rather, you are expected to apply the law. You are expected to understand a question and address it without pandering. So in this case, let's first outline that which is not relevant. So the very first element that then you need to start talking about is that of A.V. Dicey's three pillars, namely the fact that Parliament has the power to pass any law, the fact that it can't bind any successor, and that no court can hold an act of Parliament void. Now, for the observant among you, you'd understand that this particular question is actually focusing heavily on this second pillar that I noted, the fact that no Parliament can bind a successor, and also, to a great degree, the first pillar, that Parliament can pass any law. The question itself indicates that it cannot restrict or limit its own power, as well as no external party can also limit Parliament's power. So you need to go into a discussion of this. But in order to go above and beyond this fact, you need to understand that third element, the third issue that the examiner or the question requires you to address, whether you agree or disagree with this statement. Remember, it's a discussion that is expected from you, not merely reciting what you have learned in class. So because of that, the very next aspect that you might need to talk about is the modern context of A.V. Dicey's three pillars, whether his expositions stand true today or whether it has been put into question. Now, in light of this, a few good examples to note are the enactments of, for example, the Human Rights Act of 1998, which requires local courts to make sure that any act of Parliament is in accordance with the ECHR. On the other hand, you have devolution which has taken place, in which case is Parliament the only supreme lawmaking body. So always note, you are expected to have a vivid and a colored discussion in such a context because your opinion is valued in this particular context, especially when it comes to constitutional law. Don't mistake the fact that constitutional law has a heavy basis in history, so you must look at things from a historical context. But apart from that, if you are to go above and beyond and, for example, ace your examinations, you are expected to go beyond that and consider every single scenario in the modern context. Thinking about A.V. Dicey's expositions, his theories and his principles in that light makes it possible for you to have an argumentative structure to your answers, one which will provide an examiner with a breath of fresh air when reading thousands of examination scripts, including yours. If you are interested in questions of this caliber, as well as how to approach them and how to properly answer them, and perhaps receive feedback on the types of questions that you are writing as well, make sure you visit law.simplybook.me and I'd be glad to arrange a private tutoring session with you. So as always, have fun, stay safe, and obey the law. Cheers.